Welcome back to studying for the California LCSW test. I'm doing the second half of my content area 4, professional values and ethics, in the second subsection called confidentiality. Second half because this book had 12 practice questions and this book has 10 practice questions. And so let's dive right in. Starting with question 19. During a session, a client discloses to a social worker that she was sexually abused by her father when she was an adolescent. The client has never confronted her father and does not want the social worker to disclose the information. There is no legal duty to report the abuse since the client is no longer a minor. That's information to know and keep in your head. No longer a minor, so this is an adult. The client reports that she sees the father regularly and he poses no current threat to children given a significant decline in functioning. In order to handle the situation ethically, the social worker should arrange to meet with the father to formally assess the risk for reoffense. I'm just going to tell you right now that is not your job. You're not a child protective service worker. That is not your job. Seek supervision to determine whether to keep the information confidential. You already know the answer. Report the suspected child abuse to the welfare agency. Respect the client's wishes by keeping the disclosure confidential. So it's either C or D, because I've already decided no. The, the question did tell us there is no legal duty to report the abuse since the child is no longer a minor. That was C, saying report the suspected abuse to child welfare agency, and D, respect the client's wishes by keeping the disclosure confidential. D, keep the respect the client's wishes by keeping this confidential. Rationale. This big section is bolded. Ethical and legal issues regarding mandatory reporting are very clear when victims are minors. There is both a legal and ethical obligation to report all child abuse to protective services. However, when the victim is a client who is now an adult, the required action becomes less clear. Laws vary by jurisdiction, and it is important for social workers to be aware of their legal duties. Social workers face ethical dilemmas in these situations, as they may want perpetrators to be accountable for their actions. However, if clients disclose such abuse in strict confidence and do not want it reported, there is a need to respect their privacy. This abuse does not meet any of the exceptions for disclosure, such as due to consent by clients, clear and immediate danger, and other requirements by law, such as duty to warn. In these instances, social workers may provide clients with information and other support so they can consider their options more fully. For instance, they may not be familiar with what happens during abuse investigations, fearing the report may lead to immediate notoriety and broad publication. Legal and procedural protections afforded to survivors of sex-related crimes may also not be known. However, Even with such information and support, adult clients may resist wanting their abuse reported. Thus, social workers must respect their right to self-determination and should avoid imposing their own beliefs on the clients. A big section of test strategies applied. As the 2018 NASW Code of Ethics does not explicitly address the situation in this scenario, it is necessary to consider the ethical principles of beneficence, doing good, non-maleficence, avoiding doing harm, justice, and respect. While reporting the abuse may help protect other minors from being abused, it may be experienced as harm by the client, as she is not emotionally ready to confront her father about the abuse. Reporting the abuse also may have a negative impact on the social worker-client relationship, as the client may feel betrayed by the disclosure. From a justice perspective, reporting the abuse may be a method of bringing the alleged perpetrator to justice, but justice could entail prioritizing the client's emotional well-being. Finally, respect involves honoring the client's rights to privacy and self-determination. The scenario stated that there was no legal duty for social workers in this jurisdiction to report past abuse, as the survivor is no longer a minor. If it were required, the correct response may have been different. The scenario also indicates that the father is not a danger to other children given his physical and/or mental status. Meeting with the father is not appropriate, as he is not the client and it is not the social worker's role to assess his risk. In addition, while supervision is always useful, the social worker should not be passing the buck and relying on the supervisor to make the decision. The social worker must be knowledgeable about the laws and issues regarding mandatory reporting. That was a significant one. If he would be a grandpa and there was suspicion or risk that he could possibly be doing this to grandchildren, you would definitely report. Only use the information the test questions give you. If you add or take away from the test question, you will get it wrong. Question 25. Which of the following is not a condition often cited by courts that must be met in order for information to be considered privilege? So this tells you if a question like this comes up on the LCSW test, you need to know what is considered privileged information. Harm caused by disclosure of confidential information outweighs the benefits. Written records are kept documenting confidential material. Parties involved in the communication assume that it was confidential. Confidentiality is an important element in the relationship. Which of these is not a condition often cited by courts that must be met in order for information to be considered privileged? The rationale is B. Written records are kept documenting confidential material. That is not a condition often cited by courts. The right of bolded privileged communication, which assumes that a professional cannot disclose confidential information without the client's consent, originated in British common law. The attorney-client privilege was the first professional relationship to gain the right of privileged communication. Over time, other groups of professionals have sought this right. Social workers should understand the distinction between confidentiality and privileged communication. So, there you go. Another video in the future. Confidentiality, privileged communication. Social workers should understand the distinction between confidentiality and privileged communication. Confidentiality refers to the professional norm that information offered by or pertaining to clients will not be shared to third parties. Privileged refers to the disclosure of confidential information in court or during other legal proceedings. Courts commonly cite the following four conditions that must be met for information to be considered privileged. So earlier I said you got to know what these are. Harm caused by disclosure of the confidential information would outweigh the benefits of disclosure during the legal proceedings. So if it's going to do harm and it outweighs the benefits, privileged. The parties involved in the conversation assumed that it was confidential. Confidentiality is an important element in the relationship, like our clinical relationships. The broader community recognizes the importance of this relationship. A significant court decision for social workers concerning privileged communications was the landmark case of Jaffe versus Redmond, Jaffe versus Redmond, Redmond, 1996, in which the Supreme Court ruled that the clients of clinical social workers have the right to privileged communication in federal courts. Many states, though not all, now extend the right of privileged communication to social workers' clients. Test-taking strategies applied. The question contains the qualifying word "not" that requires social workers to select the condition which does not need to be met in order for information to be considered. When "not" is used as a qualifying word, it is often helpful to remove it from the question and eliminate the three response choices which are legal effects. This approach will leave the one response choice which is not a decision-making variable. While documentation is important in the provision of social work services, confidentiality and privilege do not apply to written materials. It's important to know for things like text message reminders. Be careful what is sent through text message reminders. Question 30. A mandated client questions the confidentiality of specific documentation that is generated as part of treatment. The social worker should suggest the client speak to legal counsel to determine whether the material is privileged, Review the court order with the client to determine what documents have to be released. Seek supervision and or consultation to better understand specific confidentiality standards. Explain that consent will be obtained prior to generating any documentation to maximize client confidentiality. Well, that's definitely something that will happen, right? But not the first thing. First, mandated client questions the confidentiality of specific documentation that is generated as part of the treatment. The social worker should, and the correct question is, review the court order with the client to determine what documents have to be released. Not explain. I know we had that other question that is explaining. You're not explaining, you're reviewing. He's got to be like, this is what I'm supposed to do. Okay, it says uh, like attendance records. Most of the time that I had clients that were mandated, the biggest thing is their attendance. What dates were they there? What dates did they miss? Social workers must be knowledgeable about legal documents related to confidentiality of client information. Confidentiality of mandated clients is particularly tricky as documents may be subject to release without client consent. Social workers have a duty to claim privilege on behalf of their clients when asked to release any information without client permission. Privilege is a right owned by clients to prevent their confidential information from being used in legal proceedings. The NASW Code of Ethics requires social workers to wait until ordered by the court before disclosing the information in legal proceedings, absent client consent or an imminent threat of harm. A subpoena is a mandate to provide evidence or testimony, but it is not a final ruling or order by a court on the legal requirement to provide information or admissibility of the evidence. A subpoena is not a court order. Most subpoenas are issued by the attorneys. Court orders, judges. The NASW Code of Ethics provides that when a court order disclosure could cause harm to the client, the social worker should request that the court withdraw or limit the order to keep the records under seal. It is not clear how a social worker can meaningfully implement this provision. The social worker could refuse to obey the court's order as a matter of conscience, but this should be done only if he or she is prepared to be found in contempt of court and be faced with jail time, a fine, or both. The need to be aware of court or legal mandates is the cost of doing business in a profession where clients can be involved in legal disputes or matters. A big section of test-taking strategies applied. Clients who are mandated to receive services may also be referred to as involuntary or court-ordered clients. All of these terms indicate that clients did not voluntarily choose or consent to receipt of services. There is legal authorization to mandate the receipt of treatment. Thus, there may also be a similar mandate to get access to documentation related to the receipt of services. The extent of what will need to be disclosed can vary, and social workers are advised to be aware of these limits before the onset of treatment and review them with clients in their initial meetings. In this scenario, In this scenario, it is the social worker's responsibility to understand the extent to which the documentation is privileged. So there is no need to have the client see a lawyer, which of course was what did it say? Yeah, A was suggest the client speak to legal counsel to determine whether the material is privileged. That is something the social worker is supposed to know. The social worker The social worker should be aware of any specific limits to confidentiality before the onset of services. So seeking supervision and or consultation to understand this is problematic. Documentation associated with treatment needs to be generated according to practice standards. It would not be appropriate to forego keeping notes which are essential to continuity of care, just because they may be released. Also, promising the client that he or she will be able to consent to information released when mandated by the court can be misleading. The court order and any relevant legal documents should be obtained by the social worker and consulted whenever there are questions related to the service provision and or reporting. Social workers have legal mandates to comply with court orders once they are appointed to be providers of services and agree to the terms. If there is concern about mandates in court orders, social workers should try to get them changed or be removed as treating professionals by the appointing courts. Let's move over to question number 42. Question number 42. A social worker meeting with a 10-year-old boy and his mother notices what appears to be burns on the boy's legs. Already sounds similar to a question that was in this previous video out of this book. So we notice there appears to be burns on the boy's legs. After the social worker asks about the markings, the mother provides an explanation that does not seem plausible. Same wording as in the other question. The social worker suspects the burns result from physical abuse in the home. In this situation, the social worker should contact authorities without disclosing the suspicion to the mother or child. That was A. Question the child alone to determine who is the perpetrator of the abuse. Ask the mother for evidence to support her explanation. Report the suspicions to the authority with the mother and child present. If you followed in the other video, you already know we're going to be reporting this. So it's either contact the authorities without disclosing the suspicion to the mother or child, or report the suspicion to the authorities with the mother and child present. What do you think? Well, remember some of the other stuff. If at all possible, have the client involved. So in this one, D, the rationale, effective interventions. Effective interventions depend on using the most appropriate theory and practice strategies for a given problem or situation. I'm reading the wrong answer. Hold on. It's still D, but 42. Rationale. The 2018 NASW Code of Ethics provides standards with regard to confidentiality, including the process for disclosing information as a result of mandated reporting. Social workers should respect clients' right to privacy. Social workers should not solicit private information from clients unless it is essential to providing services Didn't seem like this applied yet, but let's keep going. Social workers should not solicit private information from clients unless it is essential to provide services or conducting social work evaluations or research. Once private information is shared, standards of confidentiality apply. Social workers may disclose confidential information when appropriate with valid consent from client or a person legally authorized to consent on behalf of a client. Social workers should protect the confidentiality of all information obtained in the course of professional services, except for compelling professional reasons. The general expectation that social workers will keep information confidential does not apply when disclosure is necessary to prevent serious, foreseeable, and imminent harm to a client or others. In all instances, social workers should disclose the least amount of confidential information necessary to achieve the desired purpose. Only information that is directly relevant to the purpose for which the disclosure is made should be revealed. I'm still having difficulty, and you probably are too, with this rationale. I'm seeing abuse, and we're still in the section of confidentiality, which is probably what's throwing me. We're in the content area 4, professional values and ethics, subsection 2, confidentiality, and I'm reading this like mandated reporting. Um, it's my own transference and stuff. This next section is italicized. Social workers should inform clients to the extent possible about the disclosure of confidential information and the potential consequences, when feasible, before the disclosure is made. This applies whether social workers disclose confidential information on the basis of a legal requirement or client consent. Test-taking strategies applied. The scenario calls for reporting the suspicions to the Child Protection Agency, referred to as the authorities in this question. The social worker does not need to prove that the abuse is occurring or identify the perpetrator. That was part of B, question the child alone to figure out who the perpetrator was. The Child Protection Agency is responsible for doing the investigation. While two answers include reporting the suspicions, only the correct one involves informing the clients about the disclosure and the information which needs to be legally released without the client's consent. Informing clients, or even involving them in the process, is required when feasible, according to the 2018 NASW Code of Ethics. Long roundabout way to say, yes, you will be reporting this, and you will do it with the mother and child present if they're willing to be there. So, because this was a confidentiality, um, we're letting child and mother know, yes, you've given me confidential information, but I'm legally mandated to report suspicions of abuse. And this looks like burns. It didn't say cigarette burns or cigar burns, it just says burns. I was aware one time of a report a clinician, a social worker, did for circular bruises on the shoulders and back of a child. The report had to be made, but it turned out when the investigation was made, It was the cupping practice, where a warm glass jar is placed on the back. It, it creates a vacuum and causes blood flow to the surface. So you get bruising. Um, and that, if the social worker, if the clinician would have known about that cultural thing, they may not have made the report because that's not abuse. That's a cultural home remedy. The Child Protective Services worker came to that conclusion, and no further investigation was taken. No further action was taken. Now we're on to question 64. Question 64 says, oh, it's got a word except at the end. According to the Professional Code of Ethics, a social worker who is ordered to release information without a client's consent, and such disclosure would cause harm to a client, must do all of the following except. So one of these you don't have to do. The other three you must do. I wonder, what are the three things? What are three of the four things a person must do? Okay. Request the court withdraw the order. Minimize releasing harmful information by redacting sensitive material. Advocate to limit the court order as narrowly as possible. Promote the records be maintained under seal. Well, some of the other questions already had those two. It seems like those two, advocate, limit as narrowly as possible, would be something you would do, and promote that the records be maintained under seal could be something that you would do. Request the court withdraw the order, you might be doing that. Minimize releasing harmful information by redacting sensitive material. Let's find out what they say. Yeah, that's the one they say is you would not be doing. So you must do all of the following. Request that the court withdraw the order, advocate to limit the court order as narrowly as possible, and promote that the records be maintained under seal. You are not required to redact sensitive material. So the rationale: resisting disclosure of privileged information is required to protect the confidentiality of the clients. Social workers must employ varying methods to protect the confidentiality of clients during legal proceedings to the extent permitted by law. When a court, this is all italicized right here, when a court of law or other legally authorized body orders social workers to disclose confidential or privileged information without a client's consent, and such disclosure could cause harm to the client, social workers should request that the court withdraw the order or limit the order as narrowly as possible, or maintain the records under seal, unavailable for public inspection. Social workers can use several additional strategies to protect clients' confidentiality during the legal proceedings. If social workers believe a subpoena, remember subpoena, court order difference, if they believe a subpoena is unwarranted or without merit, they can arrange for a lawyer to file a motion asking the court to rule that the request is inappropriate. In addition, social workers may request that a judge review clinical notes and records in chambers to protect confidentiality, and then rule on whether the information should be revealed in open court and made a matter of public record. A judge may issue a protective order explicitly limiting the disclosure of specific privileged information to certain portions of a social worker's clinical notes or certain aspects of his or her interpersonal communications. Social workers are instinctively inclined to protect clients' confidentiality. Clients' legal rights to privileged communication strengthens social workers' ability to protect the clients. To fulfill their ethical duty, social workers should be familiar with the concept of privileged communication, practical steps that they can take to protect clients, and exceptions to clients' right to privileged information. Test taking strategies applied. The question contains the qualifying word except. That requires social workers to select the response choice which is not specified in the 2018 NASW Code of Ethics. When except is used as a qualifying word, it is often helpful to remove it from the question and eliminate the three response choices which must be done as per ethical standards. This approach will leave the one response choice which is not required. Redacting information is not recommended when a social worker receives a court order which mandates release of information which can be harmful without client consent. This action is probably prohibited by law as the court has requested the information in its entirety. In addition, if a social worker is successful in getting the court to withdraw an order, it would be better to not submit any documentation, even if most of the sensitive parts have been redacted. On to question 69. A social worker who wants to avoid a client, oh, I'll try this again. Nope, that was wrong word. A social worker who wants to afford a client the greatest confidentiality protections should store psychotherapy notes in a section of the client's file so that they will not get disconnected from other key documents. Of course is done, right? Separate from the rest of the client's medical or clinical record with restricted access. At home, as they are intended only for the social worker's use, according to agency policy, so the administrative standards provide additional client protections. '69. B. Separate from the rest of the client's medical or clinical record with restricted access. I'm sure they'll talk about you don't take client records home. I mean, obviously, unless your home is your office, but then you won't have your client records in the living room on the coffee table. You'll have it in your own personal office, separate from the rest of the environment. The rationale. The Health Insurance Portability and Accessibility Act of 1996, medical privacy regulations known as the HIPAA privacy rule, has important implications for the confidentiality of psychotherapy notes. The HIPAA privacy rule recognizes the unique characteristic of psychotherapy notes and defines them as notes that are recorded in any medium by a mental health professional documenting or analyzing the contents of conversation during a private counseling session or a group, joint, or family counseling session, and separated from the rest of the individual's medical or clinical records. I will often tell my clients that, they'll see me writing something down. They'll say, they might ask, or I'll say, these are the help me remember you notes, and the electronic health records are the you participated notes. Thus, any additional privacy protection that may be available to clients' psychotherapy notes depends on whether the notes are maintained separately from the rest of the clinical file. This has been interpreted to mean in a separate file, paper or electronic, rather than a subsection of the file. Underlying rational The underlying rationale is that the notes are intended primarily for use by the social worker. Access to the notes should be limited to primary clinicians. Under the privacy rule, the definition of psychotherapy notes does not include session start and stop times, modalities, and frequency of treatment, medication monitoring, clinical tests, or summaries of diagnosis, prognosis, treatment plan, or progress. If a social work practice decides to maintain separate psychotherapy notes, all of the previous listed excluded material would be maintained in the primary client chart file or medical record, while the psychotherapy notes would be kept elsewhere. Thus, the primary client chart would include, as applicable, medication prescription and monitoring, counseling sessions, start and stop times, the modalities and frequency of treatment furnished, results of clinical tests, any summary of diagnosis, functional status, treatment plans, symptoms, prognosis, and progress to date, intake information, billing information, formal evaluations, notes of collateral contact, and records obtained from other providers. That would all be included in the primary chart, separate the medical record, separate from the psychotherapy notes. The previous information would be considered the medical record for HIPAA purposes and subject to disclosure with general consent or authorization to release information as required by the 2018 NASW Code of Ethics. Under the privacy rule, in order for separately maintained psychotherapy notes to be released, the client must sign a separate authorization form. This means clients will be more aware as to when such a specific request has been made, and clinicians must provide clients an opportunity to consider whether or not they wish to sign a separate authorization for release of psychotherapy notes. Thus, if a clinician receives a request for all records or the complete medical record along with signed authorization, this is not sufficient to release separately maintained psychotherapy notes. A separate signed authorization specific to the psychotherapy notes is required. This provides an additional protection from routine disclosure of the notes to third parties such as insurers. Test-taking strategies applied. This is a recall question, which relies on social workers understanding confidentiality standards concerning psychotherapy notes. Storing them in a section of the client's file does not afford them the greatest confidentiality protections under the HIPAA. Social workers should never take client information home where there is a greater likelihood of confidentiality breaches. Additionally, Such actions violate trust, as clients are unlikely to think that their personal information is leaving the security of the professional's office. Lastly, agency policy will not provide additional protections if separate files are not maintained for psychotherapy notes. With the electronic health records anymore, um, often these days therapists will have their own scribble notes that they'll keep on paper, maybe in a manila file folder. Um, that one's empty. And that is their psychotherapy notes to help them remember what the client said last session, to help remember how many kids the client has. Sometimes people really enjoy the various things. Or if you're doing a genogram, sometimes you need a genogram. That'll all be part of your own personal notes, not the medical record. Question 75. Yes. Current guidelines considering social workers' duty to disclose confidential information without client consent to protect third parties from harm were initially established in, sounds like a recall question, case law, constitutional law, regulatory law, executive order. A. Case law. The rationale. Many ethical issues in social work, that's bolded, although certainly not all, require some legal knowledge. In addition, the 2018 NASW Code of Ethics requires social workers to consult laws that are relevant to ethical decisions. In the United States, three branches of government create laws: legislative, executive, and judicial. Only one of those was listed: executive order, regulatory, hold on, legislative, executive, and judicial. Case law, constitutional law, regulatory law, executive order. Case law is correct. Statutory laws, regulatory laws, case laws, the U.S. Constitution, and executive orders often have profound implications when social workers make ethical decisions. Statutory law is enacted by Congress, federal, and legislatures, state. Statutes govern social workers' obligation to report suspected abuse and neglect of children, elders, and other vulnerable people, minors' right to consent to mental health counseling and to drug and alcohol abuse treatment, protection of school social workers, confidential records, and federal health insurance Portability Accountability Act of 1996, HIPAA laws. Regulatory law is promulgated by federal and state government agencies such as the U.S. Department of Health and Human Services and state human service, child welfare, and mental health agencies. Under our system of law, federal and state agencies have authority to establish enforceable regulations. Public agencies must follow strict procedures when they create regulations. Example, providing public notice and opportunity for public comment about drafts of regulations. Once enacted, federal and state regulations have the force of law. Case law is created to the context of litigation and judicial rulings. For example, a judge may need to interpret the meaning or application of existing law, resolve conflicts between laws, or fill gaps in existing laws. Such rulings by appellate courts become legal precedent or case law. Constitutional law is dictated by the Constitution and includes numerous provisions that pertain to social work practice. Examples concern Fourth Amendment guidelines concerning citizens' right to privacy and protections against improper search and seizures, important in residential treatment programs, and Eighth Amendment protections against cruel and unusual punishment, important in juvenile and adult correctional facilities. Executive orders may be issued by chief executives in federal, state, and local governments. This authority usually is based in federal and state statute. Executive orders resemble regulations. Test-taking strategies applied. This question requires social workers to be familiar with a landmark California court case related to duty to warn. Current guidelines concerning social workers' duty to disclose confidential information without consent to protect third parties from harm were initially established by Tarasoff. You have to have known that. Tarasoff versus Board of Regents of the University of California. In 1976, the California Supreme Court ruled that mental health clinicians have a duty to protect potential victims if their clients make threats or otherwise behaved as if they present a serious danger of violence to another. In its ruling, the court determined that the need for mental health clinicians to protect the public was more important than protecting client confidentiality. All of this said, this was a lot of information, so I'm going to go back and read the question. Current guidelines concerning social workers' duty to disclose confidential information without client consent to protect third parties from harm were initially established in case law. Case law created in the context of litigation and judicial rulings. The example given, a judge may need to interpret the meaning or application of existing law, resolve conflicts between gaps, or fill gaps in existing law. Such rulings by appellate courts become legal precedent or case law. Tarasoff versus Board of Regents of the University of California became case law in 1976 when the California Supreme Court ruled that mental health clinicians have a duty to protect potential victims if their clients make threats or otherwise behave as if they presented a serious danger of violence to another. In its ruling, the court determined that the need for mental health clinicians to protect the public was more important than protecting the client's confidentiality. If for some reason you don't know enough information about Tarasoff versus Board of Regents of the University of California, then your school failed you. Yeah, that was pounded into us significantly. So, freshen up, brush up, whatever it takes. Because that is significant. When you think mandated reporter, you're not just thinking child, you're also thinking elder, 65 and older, and dependent adult, ages 18 to 64, who are unable to take care of themselves adequately. Question number 160. Yes? Yes. Three more questions. Question number 160, followed by 161. With regard to client privacy, privilege is best, it's capitalized, defined as the. If it says it's best defined as the, that means these four answers, one of them's probably going to be like, oh no, that's absolutely not. Three of them probably going to be close, but you'll be able to toss one out. Two of them are probably going to be so similar that if you don't know this information, you might just have to throw a dart and hope you hit the right one. With regard to client privacy, privilege is best defined as legal rule that protects communication from compelled disclosure in court proceedings. Mandate to obtain written consent from clients when information is to be disclosed. Duty to report concerns of a child abuse and neglect to appropriate authorities. Requirement to keep treatment information of minors confidential even from their parents. Well, let's see what they say. In 160, A is the best defined client privacy privilege. Legal rule that protects communication from compelled disclosure in court proceedings. Privileged communication is a legal right existing by statute or common law that protects the client from having his or her confidences revealed publicly from the witness stand during legal proceedings. Certain professionals, including social workers, cannot legally be compelled to reveal confidential information they received from their clients. The privilege protects clients, and the right to exercise privilege belongs to clients, not professionals. There are four conditions that are generally accepted as being necessary for a communication to be considered privileged. The communication must originate, must originate in the confidence that it will not be disclosed. The element of confidentiality must be essential to the full and satisfactory maintenance of the relationship between the parties. The relationship must be one that, in the opinion of the community, ought to be fostered. The the injury to the relationship caused by disclosure must be greater than the benefit gained through disclosure for the correct disposal of litigation. We've heard that sort of before, just worded a little differently. So in your studies, as you dig into it, reword it. Mash up those things a little bit, so you're connected to the concept, not the context, not the words. The landmark Supreme Court decision on the protection of psychotherapist client privilege is Jaffe versus Redmond, 518 U.S. 1, 1996. The case created by common law the right for federal litigants and witnesses to keep their private psychotherapy records out of the courtroom. Rejecting an approach that would have permitted federal judges to review and weigh the value of the potential evidence excluded under the privilege. The Jaffe decision is notable in several respects. For social workers, it is a landmark ruling recognizing the professionalism and relevance of social workers providing psychotherapy in today's mental health treatment milieu. For trial lawyers and their clients, Jaffe presented new rule of evidence, drawing a bright line around a certain type of evidence that is inaccessible for legal probing. For mental health clients, the case bolstered the wall of protection afforded to the intimacy of the therapeutic relationship. Jaffe has also contributed to the treatment of health privacy in the Health Insurance Portability and Accountability Act of 1996, HIPAA regulations. Although Jaffe is only directly applicable to cases filed in federal court, many states have had occasion to review the Jaffe decision as they decide similar matters under their jurisdiction. Test taking strategies applied. This question contains a qualifying word, best. While all of the response choices related to client privacy, only the correct answer mentions privilege being a legal term which aims to keep communication from being disclosed in court proceedings. It is best practice for social workers to get clients' written consent when releasing information, though verbal consent is acceptable in certain situations. Social workers must report suspected abuse and neglect, but such a mandate is not related to the definition of privilege, making the third answer listed incorrectly. Lastly, often treatment information of minors cannot be withheld from parents. Though laws vary across states and jurisdictions, given the ages of minors and types of treatment received, this answer is also incorrect and is not related to privilege, but concerns instead another important privacy topic. So remember when I said, when we were first looking at it, we said, whoop, best defined as, one of the answers will be completely wrong, one of the answers will pretty much be wrong, and two of them will be pretty close. Now, question 161 is our second to last question. A purpose of a forensic interview with a child is to. So, what is the purpose of a forensic interview with a child? Almost a definition answer. So, you have to know what its purpose is. Why would you do a forensic interview with a child? Identify emotional and psychological strengths to be used in successfully coping with abuse and trauma. Gather abuse or trauma histories when making sentencing recommendations for juvenile offenders. Determine the occurrence of abuse or trauma based on information that can be used for prosecution of perpetrators. Assess whether abuse or trauma has led to the perpetration of violence against others. And what's your answer? Their answer is on the next page. There we go. C. Determine the occurrence of abuse or trauma based on information that can be used for prosecution of perpetrators. That is the forensic interview with a child in a nutshell. Nothing else. Just know that. Um, A forensic interview of a child is a developmentally sensitive and legally sound method of gathering factual information regarding allegations of abuse or exposure to violence. This interview is conducted by a competently trained neutral professional, such as a social worker, utilizing research and practice. The forensic interview is one component of a comprehensive child abuse investigation, which includes but is not limited to the following disciplines: law enforcement and child protection investigators, prosecutors, child protection attorneys, victims advocates, and medical and mental health practitioners. The next few sentences are italicized. Forensic interviewing is a first step in most child protective service investigations, one in which a professional interviews a child to find out if he or she has been maltreated. In addition to yielding the information needed to make a determination about whether abuse or neglect has occurred, this approach produces evidence that will stand up in court if the investigation leads to criminal prosecution. Properly conducted forensic interviews are legally sound in part because they ensure the interviewer's objectivity, employ non-leading techniques, and emphasize careful documentation of the interview. A fuller understanding of forensic interviewing and its role in child welfare can be gained by comparing it with social work interviewing, another type of interviewing commonly used by child welfare workers. The social work interview allows social workers to assess and identify a family's strengths and needs and develop a service plan with the family. This broad, versatile approach incorporates the use of a variety of interviewing techniques. Social work interviewing is used at every step of child welfare, from intake through closure. It is used with individuals and groups, children and adults. Although it employs some of the same techniques as the social work interview, such as open-ended and forced choice questions, the forensic interview is much more focused. Generally, it is used only during the assessment portion of an investigation and involves only the children who are the subject of the investigation. Test-taking strategies applied. Forensic denotes the scientific methods and techniques used in the investigation of crime. Its use relates to the collection of evidence used for prosecution. This question requires the social worker to be knowledgeable about legal terms, and this distinction between forensic and social work interviewing. It's kind of why I was saying just know it. If you get hit with the purpose of a forensic interview question, know that they are gathering this information as part of their investigation of abuse and or trauma, neglect, and the sole purpose is to find out if somebody needs to go to jail. Prosecution. The last question for this section is question number 168. And I'll get the rationale in place. Question 168. According to the Professional Code of Ethics, that's where we're digging from, social workers who need to report suspected abuse should, it didn't say child abuse, it didn't say elder abuse, and it didn't say dependent adult abuse. You are, excuse me, Social workers who need to report suspected abuse should, even without reading the rest, I'm going to think that there's nothing in there regarding timeline, because timelines are different for kids versus adults. Social workers who need to report suspected abuse should inform clients about the need to report and potential actions which may result before any disclosures are made. Seek supervision to determine that agency policies about informing clients are appropriately followed. Inform clients about the need to report and potential actions that may result after any disclosures are made. Refrain from telling clients about the need to report and reasons for reporting in order to protect the integrity of abuse investigations. So on this one, before we go on, which answers are you throwing out? Well, there's two answers that are very similar. Inform clients, A and C. Inform clients about the need to report and potential actions which may result before any disclosures are made, after any disclosures are made. We already know a lot of times seeking supervision is usually a good thing, but it is not part of decision making. You have to be able to make these decisions on your own. Even if somebody says, no, no, don't report that, but you think you should, this is your license on the line. You absolutely, if you think you should, you're protected by law. Report. Refrain from telling clients about the need to report and reasons for reporting in order to protect the integrity of abuse investigations. Always know that if the client has given some information that is going to need to be reported, let them know. If at all possible, let them know, because they're going to know it came from you anyways. And if you let them know, it won't be a surprise. If it's a surprise, it'll damage the client therapist relationship. So, in this one, the rationale is A, the one with before. Remember, there was inform clients about the need to report and potential actions which may result before any disclosures are made. So this sounds like this is taking place like at the beginning of client contact. Hi, my name is Walter. I'm a clinical therapist. We have some paperwork to fill out. You should also know I'm a mandated reporter at some point in there. That means I am required to report if you plan on harming yourself, harming someone else, if there is any child abuse, dependent adult abuse, or elder abuse. Those are the 5 things I'm required to report. Other than that, our conversations are confidential. And on to the rationale. A. Social workers should respect clients' right to privacy and confidentiality. Social workers may disclose confidential information when appropriate with valid consent from a client or a person legally authorized to consent on behalf of the client. So there's your filling out the ROI, the release of information. Social workers should protect the confidentiality of all information obtained in the course of professional service, except for compelling professional reasons. The general expectation that social workers will keep information confidential does not apply when disclosure is necessary to prevent serious, foreseeable, and imminent harm to a client or others, such as duty to warn, child abuse, and so on. Remember Tarasoff, duty to warn. Child abuse. Enough said. Elder abuse. Dependent adult abuse. In these instances, social workers should inform clients to the extent possible about the disclosure of confidential information and the potential consequences, when feasible, before the disclosure is made. I'm going to have to make a report. Oh my God, please don't. I have a legal obligation. I just want you to know that I will be making the report. Would you like to be present when I make it? This applies whether social workers disclose confidential information on the basis of legal requirement or client consent. In all instances, social workers should disclose the least amount of confidential information necessary to achieve the desired purpose. Only information that is directly relevant to the purpose for which the disclosure is made should be revealed. Test-taking strategies applied. The 2018 NASW Code of Ethics explicitly acknowledges social workers' ethical obligations to inform clients, to the extent possible, of the need to make mandatory reports due to suspected child maltreatment. This obligation should not result in delays in reporting. Additionally, informing clients does not mean that the social worker should be deterred in any way from reporting based on clients' reactions. So, two things there. If you have information, especially if you've already told them you're a mandated reporter, and now you have information, if for some reason you were unable to tell them you would have to make a report, and you won't see them till next week or 2 weeks from now, you're going to make that report. You won't delay on it. Uh, and if you do tell them that you're going to make that report, and they make some sort of plea to not, um, you're not allowed to let that deter you. Social workers must be honest with clients throughout the problem-solving process. Clients should be aware of social workers' obligations for mandatory reporting, since it is to be discussed as soon as possible in social worker-client relationships and as needed throughout the course of these relationships. Everywhere I've worked, because I've always worked for agencies, everywhere I've worked, there's always been paperwork that has that I am a mandated reporter type thing going on. So, all right, this concludes video 2 of Content Area 4, Professional Values and Ethics, and video 2 of Confidentiality. There's another video that has 12 questions in it, so if you haven't had enough of that yet, and you haven't seen that one, go check it out. But this video is a little over an hour long, so take a break. You've earned it.